Chrissy, I had a client this morning that we were dealing with elective share, so I thought it'd be a good time for us to review elective share here in the state of Florida and talk about it some. And first of all, the term we're using is elective share. It is provided by the Florida statutes. It's part of our Florida laws here. And it talks about what your obligations are here in the state of Florida to your spouse when you pass away. Because I was telling this client this morning, he seemed quite surprised about it. And he was in a situation that's not uncommon. He's got children from a previous marriage. She's got children from a previous marriage. They have intentionally kept their assets separate. This client's home happened to be in this client's name only, not joint with his wife. And so I told him elective share is two things when he passes away. And one is that by the very fact of being married, his spouse has two rights under the elective share law, and they're two separate things. One has to do with the home that they live in, and one has to do with everything else.
Right.
And so as far as the home that they live in, which is in his name only, his wife, upon his death, will have a right to two choices. One choice, a right to live there for the rest of her life. A home, a life estate is what it's called. If she chooses a life estate, she would be obligated to pay taxes, maintenance, insurance, mortgage payments, etc. And only upon her death, many years down the road, would the home eventually go to his children. The other choice that she can make as far as a homestead is concerned is she can say, I want to take a 50% ownership, so that when he passes away, if she chose this option, she would own 50%. His children would own 50%. They would sell the condo. She would get 50%. His children would get 50%, and they would go their own ways. So that's part one of elective share.
Right.
He seemed quite surprised about that.
Oh, I would say there are many of our clients, and we're having more and more, just like your client this morning, that are completely surprised when they hear us tell them that.
Now, he was also kind of kept coming back about the issue that, hey, they may be get amicable divorce down the road. And he goes, Tom, I inherited this home from my mom. Aren't I going to, if we get divorced, aren't I going to leave with it? And I said, yeah, the possibility might be very well be yes, but we're talking about two different things. One is if you get divorced. We're not talking about that right now.
Exactly.
Two is what happens if you pass away before your wife does. That's the elective share law.
And that also is confusing to people. You're
Yeah.
right. They also can further confuse it by thinking
One
that
minute.
divorce and death are the same.
Yeah. And so the other thing is, he goes, well, okay, can I tell her, can I dictate does she get a life estate or dictate that she gets a 50%
No.
ownership? No.
No.
Elective share gives her this choice. You can't dictate it for her. You can't make it less. You can make it more. He
Right.
can leave the home outright to her if he wants to. But if he wants to give her the minimum she's entitled to, it is the choice of life estate or 50% ownership.
Exactly.
Yeah. And I'm going to talk about part two
Uh-huh.
of the elective share. We were talking about Florida's elective share law. And Florida's elective share law has to do with when you're the very fact of being married here in the state of Florida, you have an obligation to your spouse upon your death as far as what happens to your wealth and your estate. Now, the elective share law can be undone if you get a prenuptial or a postnuptial agreement.
Right.
My client this morning, of course, we always ask, do you have a prenuptial agreement? No, he did not have a prenuptial agreement. So therefore, the elective share law is going to apply to him.
Exactly.
So we talked about the home that they lived in as a married couple that is in his name only, inherited it from his mom, as a matter of fact. And so let's talk about, that's part one of the elective share, has to do with the homestead, the home that they live in. Part two has to do with everything else. And that's the assets that go through probate and assets that don't go through probate. That's going to be cash in the bank. It's going to be IRAs, retirement accounts, and life insurance.
Correct.
But let's talk about something real quick first. Anything that he owns jointly with his wife, if they have a joint bank account, that's going to automatically go to her upon their death. So we're talking about assets that happen to be in his name only. And like a lot of married couples who get married later in life, they have kept their assets separate.
Right.
He's got his bank accounts. She's got her bank accounts. So as far as the everything else, she would be entitled to a minimum of 30% of everything else.
Right.
That includes money in the bank, IRAs, life insurance, etc. And he was quite surprised to hear that as well. And so one thing I made clear to him, and that is this, is that, look, to the client, I can write you a will that says that when you pass away, everything goes to your children, but I'm going to make you sign a disclaimer where I told you about Florida's elective share law, that if you pass away first, she's got a right to a life estate or 50% in the home that you live in. She's got a right to 30% of everything else. She doesn't have to take it. You know, human nature would tell me most people would. But he wanted to go ahead and provide for her in his will because it was his intention to show this will to her. She was not here today.
Right. Okay.
She's not my client.
Uh-huh.
But, you know, he wanted to show that, look, honey, I'm doing this for you. He was asking me about, Tom, am I assured that if I get divorced, I'm going to get the home since I inherited it? And he was also talking about buying another piece of property that would not be a homestead, it'd be a vacation home for him. I said, look, I'm going to tell you what I know about divorces. I don't do divorces.
Right.
You want a final call on that? You're going to have to
Exactly.
talk to a divorce attorney. We don't have divorce
Correct.
attorneys at the Olson Law Group.
Correct.
Just
Correct.
like sometimes people ask us about taxes, and we'll tell them what we know about taxes, but we are not tax attorneys. We're not accountants. We're not CPAs. You want that advice, you got to get it from your own CPA.
And right on, because Tom, we are very quick to tell clients, because that, as you can imagine, when they're asking about estate planning, they very quickly want our tax advice. We are, all of us, we are not CPAs. We will give you the limited information that we know, but you need to back that up with the appropriate professional. And again, same thing as far as divorce. They'd have to back it up with what a divorce attorney would tell them would likely be, and or again, ultimately it is up to a judge. But we are happy to, of course, speak with them with regards to the estate planning component. And again, you have been talking a lot about and educating our listeners about elective share. Just again to confirm, elective share here in the state of Florida is about what happens when you pass away. Elective share has nothing to do with divorce.
So let's move on to a similar topic, and that is prenuptial agreements. So that the lesson to be learned about what we've been talking about the elective share is this, is that if you're getting married later in life and you've got children from a previous marriage, your partner's got children from previous marriage, your intention is to keep your assets separate, your intention is to leave your own wealth to your own children, you want to avoid the elective share where your spouse has certain rights to your estate no matter what, the way to do that is through a prenuptial agreement.